call hawks, and he needed to be able to bring order and some semblance of civility within his administration. And I hope going forward he will do so.
Larry, let me just say that I agree with Mikuna to the extent that actions speak louder than words. As late as today, you have had continuous harassment of some civil society organizations because of perceived intention to file an election petition. That was very unfortunate. A hand of friendship that is stated in words has to be shown in deeds as well. And I think that is an important point. The president needs to demonstrate that he's doing more and that he's ensuring that those who are under him, who are very excitable and very zealous in trying to bring down the opposition, which goes against democratic tenets, do not do so. But having said so, there is a responsibility to all of us as Kenyans. And I think Article 37, which talks about the freedom of peaceful assembly, says peaceably and unarmed. We must condemn both sides or all sides, whether it is Jubilee or the government or NASA supporters who go beyond the constitutional imperatives of peace, unarmed, and ability to challenge through constitutional means.
Yeah, I would say that I agree with the sentiments across here, that the president was responsible in his address. And if I recall, he said very well that even if the NASA supporters want to go out and protest, they don't need his permission. They can go out, protest peacefully, and all will be well. But again, the other thing that has been doing rounds in social media, people have been pleading out to others, please celebrate in humility. I've seen a lot of those WhatsApp messages going out, that those of you who are celebrating, celebrate in humility. You're not going to go to your neighbor's house because now the country, we are all divided. You're either NASA or you are Jubilee. So you are a Jubilee, you are running to a NASA gate and screaming happily, whereas you know your neighbor is hurting. So I think people have been going all out in a responsible way to say to each other, let's celebrate, or let's accept results in humility, knowing that this country belongs to all of us. And that also goes to all the leaders on both sides of the divide. This is not the time Kenyans want to hear irresponsible statements. That could not be tolerated during campaigns. They were grueling. This time round, the leaders and first of all, the president has a responsibility to unite the country. So the last thing we want to hear is any statements that will divide the people further.
All right, I talked about what the NASA case is likely to be in the Supreme Court when it comes up, hopefully in the next few days. I want to play for you what Raila Odinga said today in deciding that they were going to go to the Supreme Court after all, which they had initially ruled out. Watch.
Wengi wa Kenya walijitokeza kwa wingi zaidi kupiga kura. Lakini yale yalifanyika yamejulikana. Nasema wa Kenya hawezi kuvumilia tena wizi wa kura. Haya viongozi ni vifaranga vya kuku, vikaranga vya kompyuta. Kompyuta ndio iliwataga, kompyuta iliangulia, kompyuta ikawatoa. Vifaranga vya kompyuta.
Biguna, your reaction?
I want to be fair to the Right Honorable Prime Minister. He was speaking as a candidate, as a presidential candidate for NASA. And he was speaking as an aggrieved candidate. He was not speaking as an advocate for Raila Odinga. And he was not reading submissions to the Supreme Court, nor was he referring to briefs filed before the Supreme Court. So his was a political statement. And as far as political statements go, I don't find anything wrong with what he said. Because that is not his case before the Supreme Court. We have to wait for the case NASA will file before the court. And we cannot rely on clips to judge the quality of evidence that NASA is going to present before the court.
At least we have a general sense of what that case might be, because he said we have now decided to go to the Supreme Court to prove what a computer-generated leadership this was. Understand?
My question that I'm asking the former Prime Minister, when he calls other leaders vifaranga, what does he want to tell the Kenyans? Is that the narrative? Is that the rhetoric? Is that the language towards when this country is so polarized? It is not the best mode of communication. The NASA leader read a very good report or statement. I wish he could have finished from there. After he started talking in Kiswahili, he created his own blunders. And these are some of the reasons Raila always destroys his case every time he moves away from the written speech.
Okay.
Number two, from the speech that he wrote, you'll see that he's talking about failure to comply with the law in terms of transmission of the results. Number two, a consistent pattern in terms of the pattern of either 11%, the difference is always constant, not only for the presidential campaign, and also some gubernatorial positions. The third argument he generates is that there must have been hacking. So all that we are saying, none of us knows what Raila Odinga has, because he can say this thing, but as lawyers, until the application has been filed, their nextures, what we call the supporting documents, have been presented. Okay. And IBC files theirs, Jubilee files theirs, then we'll be able to say he has a good case or he doesn't.
Lillian, how do you go about proving, as they say, that this was a computer-generated leadership, so alluding to the hacking? Because the logs of the supposed hacking have been criticized and delegitimized in the court of public opinion by experts who say this does not prove anything.
Yeah, of course, until the case is heard in the Supreme Court, we cannot preempt anything here. But I think listening to that statement, one would be tempted to laugh or, find it funny. But what Miguna has said is true, that this is coming from somebody who is hurting. And hurting and looking back at where he's coming from. But sitting where I am, I would say this, that the elections law had only one provision on the deployment of technology in elections. But in 2016, the law was amended, and that one provision was repealed to bring in a raft of many other provisions in terms of what kind of technology to deploy, how you're going to store your data, access to the codes, the KIMS was introduced, and so many other things that are in Section 44 of the Elections Act. Now that we had all that and ready to conduct this election in 2017, we are now faced with another situation where we are going to delve deeper to find out what happened. There is now hacking. Yet, remember again, we have Form 34A right at the polling station. That is a hard copy. We are talking of a hard copy that was signed by the presiding officer, the agents, then it was scanned and transmitted to the constituency tallying center, to the national tallying center. So you have a trail of papers where you can trace where you are coming from. Okay. And this is the evidence we want tendered before the Supreme Court. Remember, IBC will have 48 hours within which to present all the documents that they used from the polling station to the constituency to the national tallying center. So they have to be prepared. They are not going to go to the Supreme Court and tell the court that we do not have Form 34 and we need more time. Yet we only have so many days, 14 days, within which the Supreme Court must hear and determine the case. Right. So I think we have brought this on ourselves, if I may say, as a country. We insist on technology. And technology must be used in a way that is transparent or perceived to be transparent to the nation. Right. So I think these are issues that will be unfolding in the Supreme Court, and I cannot say much for now, but I think people will be waiting for the evidence and not just rumors and propaganda on what happened or what may or what could have happened. Bring the evidence, and on that basis, the court can determine the case.
Kanjama, your sense of how this case ends, or how it must play out before the Supreme Court if they present a strong case?
Larry, Section 83 is the only one I'll cite of the Elections Act, is the fulcrum upon which this case is going to rest. It's a very important provision. The Supreme Court in the Raila case, in the other election cases that they dealt with thereafter, Hassan Joho case, Peter Munya case, and so on, have referred to it repeatedly. The courts of appeal, the High Court in Kenya have referred to it. It's a provision that comes from English law, but which we have adopted as part of our constitutional interpretation of framework. It says that no election shall be declared void by reason of non-compliance with any written law relating to that election, if it appears that the election was conducted in accordance with the principles laid down in the Constitution and in that written law, and that the non-compliance did not affect the result of the election. So our courts have basically come up with two tests. One is called the qualitative test. In other words, looking at the non-compliance, because there's no election which has 100% perfect compliance, whether it is in America, in the United Kingdom, in France, or in Africa. There's no election where everything is perfect. So what the courts check is those instances of non-compliance, qualitatively, were they so significant, so substantial, that they distorted the constitutional principles for free, fair, credible, and verifiable elections. They have to be substantive, you have to show a pattern, and not just distorted instances here and there. Then the second test is the quantitative test, which is even more significant, because the Supreme Court in the Raila versus IBC case referred to it, the Supreme Court in the Joho case referred to it, and the quantitative test is simply this. Those instances of, for example, wrong results that you are referring to in the Form 34's discrepancies, when added together, do they bridge the gap? In this case, do they bridge the gap of 1.4 million votes? And what I would say, Larry, is this. If you notice during the presentation of evidence, during the presentation of the case, that NASA's case is tending towards overemphasis on these electronic algorithms,
right,
it will be a clear indication that they are heading down the wrong path. For the simple reason, and again I'll use two words, inbuilt redundancy. The electronic transmission system was an inbuilt redundancy, while the actual method that was used to compute the votes, as Lillian has explained, was through physical forms that were transmitted from the polling stations to the constituency tallying centers, the national office. So they would need to actually go beyond the, what I would call it, focus, the spatial
So the
focus.
case cannot hinge on this supposed hacking of the IBC transmission or the server.
Let me put
That's
it
what you're
this way.
saying.
As somebody who has studied and been involved in electoral cases, if you find that their case is hinging on that fact, just cross it off. You know that it will not head to a final determination. Right. Because those final tallies did not come from the server.
They'd have to be in the physical
They
forms.
came from the form 34A, 34B, 34C. And I think if Kenyans were to just study the way the Form 34A looks like, the way the Form 34B looks like, with the tallies of each Form 34A, the way the Form 34Cs look like, just visit the portal that has been opened by IBC of forms, you'll realize that you can use the electronic argument to show that there was a climate created to try and steal the election, which is what I think NASA will be trying to argue. But if your main argument is that the election was stolen through a computer algorithm, and yet the Form 34A, B, and C was not computed through that computer algorithm, you've walked down the wrong path, you've ended up in the wrong destination.
Larry, I want to say that I agree with Kanjama on his legal premise. The Section
83 of the Elections Act. When
I agree with him and his analysis of it and how it would impact on the outcome of the decision. But I believe that his illustration is actually off the mark given what NASA said. And this is what I would like to say. NASA, and I've listened to them very carefully, they have alleged that Raila won the election.
Yes.
In fact, before the declaration of the elections, they cited a numbers. They said Raila Odinga got this, Uhuru Kenyatta got this. The question that a lawyer would ask is, do you have the evidence? Because if they do, then of course it will change your argument, Kanjama, because they would be able to demonstrate that.
When they gave those numbers, Miguna, they said that a confidential source of the IEBC had told them that those were the actual numbers in the server.
No, regardless of whether the source is confidential or not, as a litigant, as a lawyer, even as an advocate who litigates cases, you know that sometimes you may not be able to tell your opponent who the witnesses are.
Yes.
But then at the time of litigation, you will be able to say who these people are and be able to demonstrate that what you have is credible. So I hope that they do have that, confidential or not. So you secure your witnesses and then you produce the evidence.
All right.
The second thing is that, and what troubles me, is that the IBC itself has not been able to say that they have all Form 34As from which the numbers came from. Now, assuming NASA does have all 34As, which IBC has not disclosed, and then at a certain stage, IBC discloses Form 34As, which are different from what NASA has, and NASA sources are the same as IBC sources, then you can see that, and Kanyama knows, when it comes to issues of litigation, credibility accounts for 80% of the case. If NASA can demonstrate that the evidence that IBC has produced is so tainted with some kind of conspiracy or whatever it is that they can be able to demonstrate and attack the credibility of IBC officers to the extent that the court does not believe anything they produce, then the quantitative part of it becomes nugatory.
All right.
Because the court then will say, because we cannot trust you, because we do not believe you, it does not matter how many pieces of paper you produce before us.
All
This
right.
case...
I
yes.
agree with Miguna,
Yes.
only to add that for the qualitative test in this particular election, NASA will need to aim their guns, not just at IBC. They'll need to aim their guns against Jubilee, which has similar figures. They'll have to aim their guns against several observers, including Election Observation Group, ELOG,
Okay.
against probably even people in the media. So they'll have to bring down several people to be able to discharge the qualitative test. I'm not saying they can't do it. Of course, they can do it if they have the evidence required. What I'm saying is that they have the work cut out for them.
The work cut out for them, Dunstan, as you make your final comments, what they have to prove is what I think the statement stood out, and Kevin Kyoga in fact tweeted it, that it was a computer-generated leadership, they called it, which is voted by an algorithm that transmits results in a consistent disparity across the system. So that's part of their argument.
That is a question of statistics. It will not be an argument, a legal argument, to argue that this has never happened, therefore it cannot happen here. You must prove that indeed whatever is that algorithm is generated by one or two issues. Number two, when you look at NASA's allegation, and it's a very serious allegation that there are polling stations that are not gazetted. If that is proved, that there were polling stations that were not gazetted, what means is that there were votes that were pumped into the IBC servers from non-people, either dead people or imaginary people,
Or people
who ought not to have voted. If that can be proved, that will be very fatal to the election of President Uhuru Kenyatta. In another way, NASA has been talking about the server. For the benefit of Kenyans, NASA can make an application as the first thing to be decided that they want an order for that server, the content of that server to be produced in court. What is in that server that Chebukati never wanted anybody to see? In my own submissions, I think that all that, Larry, we've done here is purely academic.
Right.
The reality is either tomorrow or Friday, when we have the documents presented in court with all the evidence that NASA has. My good senior here, my chairman, has said it, that in 2013, NASA lost because they thought they will ambush the last day and file
this 800-page
yes,
submission. Yes.
This time they have learned a bitter truth. I think that between
Maybe
NASA...
it was not strategic.
Yeah, I'm saying, I think between NASA and the IBC and Jubilee, NASA must be prepared more better because they've lost, and the bigger burden for them is to prove that they have a case before the IBC starts rebutting, or before the IBC, we said we don't become lawyers, before the IBC and Jubilee started denying that what these guys are saying does not exist. We wish all the parties success. And my final take is that I hope that in the next 14 days, this country remains intact.
Okay.
Nobody causes problems. Let us give the judicial process time so that the lawyers will work tirelessly and the decision will come out.
Lillian gets the last word.
Last week I saw the technical team. We were here watching the technical team of NASA saying they were still waiting for all the forms.
Yes.
And they acknowledged that they did not have the technical capacity to go through all those forms that they had and know exactly what was what, and it was going to take a long time for them to determine exactly what was wrong or what really happened. But having said that, I think I would say the primary documents we are looking at are the forms 34A, 34B, 34C. Those are the primary documents. And those are the documents which we will expect the IEBC to produce once the petition has been filed. And I've said IEBC will have 48 hours to do so. So having again said that, I think the issue of the servers or not, as I said, the Elections Act is quite elaborate on how we are going to deploy technology, the access to that technology, and how it will be used even during the presidential election. The onus now will be on NASA to prove this system that we deployed, that IEBC deployed, was hacked, and because it was hacked, this is the result we have. But we cannot sit here and discuss that this was computer generated. Computer generated, no. We know the procedures right from the polling station. This document, the form 34A, is the document upon which all the results from the polling stations are all sent to constituencies and to the National Tallying Center. So let them rebut that before the court, and we see how the case goes.
Great. Do you think this, some NASA supporters might be a little apprehensive about taking this to the Supreme Court, given how NASA prefaced this by saying we're not confident Uhuru Kenyatta has won a lot more cases than we have? Is this likely to be adjudicated fairly, in your own opinions?
NASA supporters, it's not their prerogative. The decision has already been made by their principals. The matter is going before the Supreme Court. Whether you are apprehensive or not, the ultimate decision will be made by the court.
Okay. Your view?
I think we need to encourage Kenyans to build confidence in the Supreme Court. We know that the people who will be making the decision are human beings like we are, but they are specially trained. They are among the best that we have to offer. They have risen to that high position. They have taken an oath of office, and we have to be confident and hopeful that if given the law and the evidence to support a particular argument, and with the whole country watching, they will make the right decision.
Okay.
And we will be bound by it.
Dunstan?
My last submission is that there is the political gimmick that NASA is playing, saying that, oh, we cannot verify these things, oh, we are weak, oh, it might be a strategy. You remember what Ojamong did in Busia? He appeared to be the weakest candidate. What happened after the results were announced? So I believe that the Ojamongian theory might be used by the NASA theory that having lost in 2013, they know very well where they went wrong.
All right.
Jubilee has never lost in a presidential campaign. They might not have prepared.
There was no Jubilee.
So, whatever it was. If you look at the way the timing NASA has been playing, oh, we will not go to the Supreme Court. Oh, we will not go to the Supreme Court.
Now
Today, the media was prepared for a different story. NASA says we are going to the Supreme Court. So in my own view, I think that the game of camouflage, the game of decoy is part and parcel of the legal and political process. We are yet to see what is in store for us.
I think I must add here
really
that
quickly, yes.
It's not fair that NASA has given that statement today that they hope the court will redeem itself this time round. That is politics.
Yeah.
And you cannot put politics in a matter that is as weighty as this.
All right.
Yeah, and this is why we are saying...
a politician.
We know that, we know that, but
to the ICC.
Yes, in terms of the petition going before the Supreme Court, it's a matter of law, and that is it.
All right, let me read some tweets real quick before we go. Joe Opu says, I'm surprised that Saint Omari, he put that in quotes, finds fault in Raila calling people vifaranga, yet totally okay with him referring to people as hawks.
And robots.
You don't find Raila, you don't find anything wrong with the vifaranga, but you find you're okay with calling people hawks.
It is purely the semantics.
Okay, great. Josh Karoki says Gambians must be laughing at our digital polls fiasco while they voted out a dictator using marbles. You all remember that?
Yes, of course.
It's a great sense of humor, Josh Karoki.